And looks like we're live. Hello, everybody. Hope you all had a Merry Christmas. I am Brady, aka the War Hamster, guest hosting for Andrew, whose family got the flu. He may be ducking in. With me, of course, is Douglas V. Gibbs, and this is, I guess, episode 18 of the Constitutional Roundtable. How you doing, Douglas?
I am doing well, sir.
Well, we got a couple of good things lined up to talk about tonight. What's on your mind to start with, and I'll start working on what we discussed.
All right. Well, I just did a video prior to getting on the air here, and I had also written an article about this, but I believe it's something that both of us could talk about a little bit because it was the article was interesting. It was at Epic Times. If you go to politicalpistachio.com and you scroll down to the article that, as a matter of fact, I'll give you the title right now. It's like the fifth one down, and the title is "States Discuss Constitutionality of Executive Orders." That's the article that I wrote. In there, there's a link to an Epic Times article, and if you want to click that, Mr. Warhamster, you'll be able to, if you have an Epic Times subscription, you'll be able to get along with me on this one. Now, here's the reason why I bring all this up is because one of the most common questions I get from people is executive orders. And it's partly because the executive orders, first of all, the name executive order, you've been ordered. Yeah, well, the term order, the word order wasn't actually added to that until during the progressive era, during the early 1900s.
Of course,
the progressives see it as an order. The founders call it a presidential proclamation. Presidential proclamations could also include executive actions, letters, memos, things like that. We have now separated them in our current world of politics. So you have an executive order, you have executive memos, you have executive letters, you have executive actions. And the executive orders are numbered. They didn't used to be, but they are now. And George Washington issued, depending on who you talk to, anywhere between 1 and 8 of them. 8 is the actually more accurate number. And I could tell you a couple of them off the top of my head. The very first one that he issued was a letter to his executive branch. It basically said, okay, we're new at this. Let's get to know each other. What is your job? What do you think you should be doing? How am I supposed to work with you? How are we going to make this happen? I mean, that essentially was what his first executive order was. Thanksgiving proclamation, that was also an executive order. Executive orders are, from a constitutional point of view, not listed in the Constitution, but we do know what they're not. Article 1, Section 1, all legislative powers herein granted shall be vested in a Congress. And so that means that executive order, since it is coming from the executive branch, is not legally binding. Legislative powers, the power to create law, to start the bills that become law, belongs only to Congress. Excuse me. And so we know what executive orders are not. Now, with that term order in there, we have this idea, this belief, excuse me. I decided to get a frog somewhere in my throat and got to get rid of them. But anyway, so this idea of executive orders, with the word order, we get back to the progressive era, and Teddy Roosevelt broke all the records when it came to executive orders. Up to that point, there had been a handful of presidents that had gotten in the hundreds, but for the most part, executive orders were not handed out like candy on Halloween. But when it came to Theodore Roosevelt, matter of fact, I'm going to look it up because I should have this list ready. All right, here we go. Executive orders by president. It's an interesting list. So, according to this list that I looked up at UCSB, that's University of California at Santa Barbara, George Washington had 8 executive orders. John Adams had 1. Thomas Jefferson 4. Madison 1. Monroe 1. John Quincy Adams 3. Then the father of the Democratic Party, Andrew Jackson, lurched it up all the way to 12, double digits. You have no president reaching into the hundreds. In fact, only 2 of them getting above 35 or higher. I'm sorry, 3 of them until you get to Grant. Ulysses S. Grant had 217. Then it drops down again, 92. Then Garfield had 6. Of course, he didn't live long either. Arthur, 96, and so forth. And then you get to Theodore Roosevelt, 1,081.
Yeah. I've had long ongoing debates about Teddy Roosevelt, and you and I have talked about this. He was really the first progressive president.
Yeah.
It's another case of the media or the historians build a narrative around somebody and becomes bigger than life and completely the opposite of what the truth is. He's a great example of that.
Well, now here's what happens. Now Franklin Delano Roosevelt has the record, 3,721. Some of these presidents have a lot, not because they were using them for nefarious reasons, but because they were using them to reverse a previous president's executive orders. That was the case of Reagan and Trump in many cases, and in Calvin Coolidge. He was reversing an awful lot of the ones before him. Harry Truman, 907. When it comes to good old Biden right now, he's numbered at 106. Now, early on in his presidency, during the first 6 months, he was on pace to write as many as Franklin Delano Roosevelt.
Yeah, and about half of those were overturning Trump executive orders.
Absolutely. But they say, oh, but now he's, curtailed how many he writes. No, what he's doing is now he's writing executive letters and memos like Obama began to do when he saw his number getting close to Bush's, and he didn't. And after hammering on Bush for all of his executive orders, he realized it probably wasn't a good idea to go over Bush's number. So what Obama did is he began to issue letters and memos, which don't get numbered, aren't counted. But anyway, now the reason why I bring this all up is executive orders early on were used sparingly. Progressive era, suddenly they became this big deal. If you read Theodore Roosevelt's writings, he believed that the executive branch should be the strongest branch. The president should be able to do whatever he wanted. And whatever he did was constitutional by virtue of the fact of, 1, nobody stopped him, and 2, that there was nothing in the Constitution that said he couldn't do it. That was his attitude. Of course, that's the exact opposite of how the enumeration doctrine actually works. Okay, now here's the reason why I bring all that up. So if an executive order is not supposed to be an order, it's not legally binding, then what is it? All right, so the executive branch has departments, offices, agencies, and department heads, and all this other stuff. So executive orders can be, among other things, a communication with the executive branch on how to carry out the duties that the president would like carried out. He's the head of the branch, and everything is done in writing. Executive orders, executive letters, except these are, hey, person in charge of such and such department, here's how I want you to do this. But he doesn't just say it, because the founding fathers believed in transparency, and so everything is written. If we go to Article 1, Section 8, as a matter of fact, I'm sorry, not Article 1, Section 8. I jumped the gun there. Now I got to find it real quick. Once again, I should have been more prepared knowing I was going to talk about this, but I wasn't thinking until I got to thinking.
Well, while you're thinking, I'll just comment that it's funny you mentioned all these different departments that fall under the executive branch.
Right.
We haven't gone through that list of all the ones that shouldn't even exist in a while.
Oh yeah.
Yeah. I mean, it's just But just about every three-letter agency out there has no reason to exist under the enumeration doctrine.
All right, Article 2, Section 2 is what I'm looking for. So it says that he may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of the respective offices. Well, if he expects the answer to be in writing, how is it going to be presented? In writing. So the communications between the president and his branch, his department heads, is in writing. Executive orders, executive memos, executive letters. And also, an executive order can be used as a proclamation. Now, a proclamation could be a Thanksgiving proclamation like George Washington put out. Hey, I think it's a good idea. We all give thanks on one day together. But it's not legally binding. Remember Article 1, Section 1. So it's not an order that you have to give thanks.
So when they make it a national holiday, there's no force of law behind that. It's just observed.
Well, if it's done through Congress, then it becomes a law. But if it's done through an executive order, then no, it's not officially.
So walk me through this process. So Christmas Day fell on a Sunday this year. So Monday was declared a national holiday. Now they knew that 200 years ago what the day Christmas is going to be in 2022. But when did Monday be declared a national holiday? Who did that, and what's the force of law?
Let's stop right there and ask a question first before we even go that far. Where in the Constitution does it say that the federal government can use legislation to declare any day a national holiday?
I don't think it does.
Well, it doesn't. You're right. So first of all, these declarations of national holidays are unconstitutional. Now, does that mean I think it's a bad thing? I don't know. I suppose it could be a good thing. But if you're going to do it, should you not have, I don't know, the permission, the authority?
So would you want
an amendment saying, hey, we give the authority to the federal government to declare certain days holidays, federal holidays or national holidays where someone doesn't have to go to work and they still need to get paid by their employers or whatever. So first off, they don't have the authority in the first place. But get back to these executive orders. So if we are understanding then that an executive order is either communication with the executive branch or a proclamation, like the Thanksgiving Proclamation, the Emancipation Proclamation, Ronald Reagan signed a National Day of Prayer proclamation. It's not legally binding. You don't have to pray on that day by law. It's a suggestion by the president. Hey, as a country, we ought to do this together. But it's a suggestion. So first of all, I wanted to get that out of the way. Now, the article that I'm referring to, GOP-controlled state legislatures weigh constitutionality of presidential executive orders. Okay, so what executive orders do they need to weigh the constitutionality of? First of all, we must ask, well, is it regarding a law? Well, if the law is constitutional, then the executive order to carry out that law would be constitutional as well. So the question there wouldn't be whether or not the executive order is constitutional, but whether or not the law is constitutional in the first place. So we're not talking about executive orders attached to laws. I don't believe when we read this article. So then that means it's maybe over proclamations. Is the state worried that a proclamation is unconstitutional or constitutional? No, because they know it's a proclamation. It's not legally binding. So that means this article is not addressing that. That leaves only one thing. That leaves executive orders that are being treated as law. Orders to the state. You must do this, or you must carry out this because there's some emergency or something like that. So the question is now, why are the states deciding that they need to come up with a committee to review presidential executive orders not affirmed by a congressional vote? That's what it says in the second paragraph. Review all presidential executive orders not affirmed by congressional vote to determine if they are in fact constitutional. So we know they're not talking about executive orders attached to laws to carry out a law. That's not what they're talking about. Not talking about proclamations. We're talking about executive orders that are put out that are treated as if they are law. Remember, no executive order is legally binding. Then we must ask, well, what kind of thing are they talking about? Well, they could be talking about executive orders regarding ESG standards, or whether or not you should have to put a medical device across your mug.
Or perhaps inject an experimental inoculation.
Or anything like that. So the question is now, the GOP legislatures are saying, we need to review these executive orders to determine if they're constitutional. I wish they'd just call me up. The answer is very simple. If no executive order is legally binding, unless it's carrying out a law which is legally binding, then it's not constitutional. If it's being treated as if it's legally binding, in other words, and there's no legislation attached, it's not constitutional, because there is no legal authority for the federal government through the president to make you do anything.
Yeah, well, the article you have on Political Pistachio, I was reading it as you were talking. The congressman was talking about there being 3 branches of government, and one of them is supposed to legislate. And we sit here, we live in a country where all 3 get to legislate.
Yeah,
it's a bit of an issue. You got the executive who's supposed to execute laws, is making law, and you got the judiciary who's supposed to, well, I'm not going to use the word interpret, supposed to apply the law.
Apply the law.
Yeah.
And they are. And they basically rule by fiat with, making, their own laws up as they go along, or repealing laws.
Well, remember that point that you just made right there when we get into the Brunson case, because that's going to come up.
Okay.
Are you ready to skip over to that, or?
Yeah. So let me wrap this up real quick. So when it comes to executive orders, understand we have 3 kinds. We have 2 legal ones and 1 that isn't. A legal executive order is either there's a piece of legislation and the executive branch, the president, has issued this executive order for the purpose of carrying out that piece of legislation. Or it's a proclamation, which everybody knows is not legally binding. The third one, which is what's being addressed here, are executive orders that mandate or an edict, which are not supposed to have any legal authority or are not supposed to be legally binding, but they're treated as such. And the very fact that the state legislatures feel that they have to review them to determine if they're constitutional tells us actually how far from the proper path we are. There should be no review. There's no discussion. If it's not attached to a piece of legislation and it's being treated as if it's legally binding, it is unconstitutional, and the states can tell the federal government, the president, sorry, we're not following it. We nullify it.
Yeah, the idea of reviewing laws if it's not legislated is great, but I'd like to take it a step further and have them reviewing stuff that is legislated.
Mm-hmm.
And I'd like, me, I want to see a whole heck of a lot more nullification.
Sure.
But
okay, so that was what I wanted to bring up, as now the War Hamster has his thing that he wants to talk about.
Before I jump to that, because it's related to what you talked about, we really need to go through the Texas GOP, what they at their convention, what did they put their platform they put together, and it's a long one. We could do it over several weeks, but it talks about a lot of these things. Mm-hmm. So you do have a lot of state legislators that are waking up. They understand the Constitution, and they're doing some pretty good things. We're moving back in the right direction, but it's gonna take time.
Well, everything's a process. I say this in my class all the time. One of our difficulties as Americans, as we live in a society where we expect instant gratification. We have these devices with us that gives us instant gratification. We want to look something up, it's there. We want to call somebody, whip it out. We we received a message, open it up. Everything is instant. And the thing is, there is not going to be an instant solution to what's going on. It takes time. It's a process. And part of that process, I hate to say it this way, is, well, different people, including those that are in positions of power, to wake up and to realize the truth. Because right now, and this is going to tie into what we're getting ready to talk about, people like me, we are called things like, well, a purist. But, it's been debunked now by judicial interpretation. Now, this is really the way the country runs. And tyranny is running rampant because of that attitude. We need to get back to what was originally intended. I may be a purist, but it doesn't make it a bad thing. It's a good thing.
Well, on the Brunson case, for those who do not know, a week from today, the case of Brunson versus Adams is going to be discussed whether it's going to go in a conference or not in the Supreme Court. I forgot the exact terminology. We'll get there in a second. A lot of people on the internet are getting very, very excited about this Brunson case. And, we'll go through what all the details are. We found Tracy Beans wrote a really good article. Very interesting article, actually. Made some good points. I think Doug agrees with some and may not with all. And we're going to go through that. I've been cautious about the Brunson case since it first came to everyone's attention. And, one of the reasons it's getting so much hype is Lloyd Brunson, one of the Brunson brothers, is making the rounds on all the influencer channels and marketing this up and says, we're going to reinstall President Trump and fire 385 congressmen. And I've been saying that's probably not going to happen. The Supreme Court does not have that power. So even if you were to get your case heard, somehow get it argued.
The old saying goes, if it sounds too good to be true, it probably is.
Yeah, so he's marketing the heck out of it. People are getting very excited. It's a big, giant dose of hopium. I find the story of how it got to the Supreme Court to be more interesting than the case itself. Mm-hmm. But we're going to go through it. So let me pull it up. And I don't even know if we're getting an answer on Friday, unless it's an absolute no, get the heck out of here. But that's the one thing I have not found out. So an undercover DC, which is a pretty good, what do we call it? Set of journalists. They write good articles, and they actually do. This is one of the better sources out there. And this is came out today from Adam Carter and Tracy Beans. I've been following Tracy Beans' articles and her writing since around 2016 when she started covering the Spygate issue, and she's been a pretty solid reporter. So I give this, I give her.
And when you say a solid reporter, from what I've understood in the past, I've seen is someone that doesn't necessarily try to lean one way or the other, but just report the facts.
Oh, you're talking about objective journalism, journalistic integrity. Oh yeah, that stuff. Yeah.
Oh yeah, that stuff.
She's one of the good ones. So
okay.
Anyways, we're going to go through it. She starts out by saying this column isn't going to earn anyone money or make a whole lot of friends, and she's right. She opens it up with a David Nunes video where he talks about this is over. We want every damn bit of evidence that every intelligence agency has, or maybe it's time to shut those agencies down because at the end of the day, our liberties are more important than anything else we have in this country, and they've been stampeded over by these dirty cops in the Democratic Party and the media who fails to report it. What Devin was talking about there was all the Spygate documents and how they were spying on him as well.
Yeah, the Russia. Yeah,
exactly. So they're right. There's many hoping for a Hail Mary to come from this Brunson case. Where we restore the republic. Well,
it gets back to that instant gratification thing I was talking about.
Yep. She goes, sadly, there are people out there who will exploit, profit from, or simply grift off that desperation by filling the need with false hope or hopium. And that's what she's calling Brunson versus Adams. So where does the case really stand? It is not scheduled for a hearing before SCOTUS. So far, it is simply a petition for a writ of certiorari that has been scheduled for conference. All that requires is filling out an online application and paying a filing fee. It's difficult.
It's basically, for those that are watching, it's basically a request to at least be reviewed, to be looked at. No ruling. Nothing that goes one way or the other. Just we're going to look at it. That this is a request to be looked at. That's all it is.
Yeah, and that's going to happen this Friday. And she'll talk about this more in the article. But a lot of petitions get to this point in time, and very few of them are actually read.
Yeah, matter of fact, as you scroll down, that next paragraph just below that graphic that video you've got on there, it states that the justice considered 158 petitions. They denied 157 and took one. So that tells you the percentage chance you have of using a writ of certiorari to request a review. But at least they're getting in front of them. At least they're looking at it. But that doesn't necessarily mean that you're going to win the lotto.
Yep. And Robert Barnes is a pretty good attorney. If you don't know who he is, he's on a number of the law channels, both YouTube and Rumble. I don't always agree with him, but he does know what he's talking about, and that's a very credentialed guy, and he's right more often than he's wrong. It's every justice claims they read every single petition, but he says no. They got a bunch of court clerks that do most of the reading for the judge, and they basically screen and filter what gets to the judge's eyes. So the odds are pretty good that not a single Supreme Court justice is ever going to read the Brunson case. These clerks are a pretty darn good filter. They know what their judges or their justices.
I believe Alito and Thomas may do a scan through it, may read it. It's not a real long. It's just a few pages. It's not real long. But I do believe that Alito or Thomas may give it a little bit of time a day.
It says down here, only 25% of petitions distributed for a conference are even discussed. So if it doesn't get flat out rejected, filtered by the clerks,
right,
then it actually gets to one of the 10 or 20 they're even going to discuss on Friday. It's got about a 1 in 5 chance of that being. Now, you may be right.
Sentence is a key sentence here. The other 75 to 80% of the petitions are denied and discarded, likely without the justices ever reading them or even being aware they exist. So that kind of goes back in what you were saying about it. Really, they stay in the bureaucratic part of it among the clerks, and the clerks then screen out. There's a lot of stuff they may not even know it existed.
Yeah, and that goes back to what I was saying about Lloyd Brunson going out and doing his great marketing tour, his PR tour for his case over the last month or so, and he's gotten a lot of attention. Maybe that's enough to get a judge to say maybe we'll take a look at it.
Right.
My opinion is that it's this thing got thrown out of court really quickly at the lower courts, and it didn't take long at all. It was like, get out of here
without prejudice.
Yeah. And I probably should write. Now's a good time to bring up. I was invited onto a conference call as part of that PR tour, Zoom call. Some local influencers had Lloyd Brunson on. About 30 or 40 people were on the Zoom, and he spoke for about 30 minutes. And that's where I learned the story of how he worked his way through the courts. He seems like a nice enough guy, but if you read this thing, the case with a critical eye, you have a pretty good idea where he got his ideas of how to practice law from. Him and his brother they've been involved in a lot of cases out of Utah over the last decade plus, and they read very much like they've got some kind of a sovereign citizen training. And apparently his brother found some injustice in life, went online and started reading about it and dove into one of these courses. And now he's been practicing as a citizen attorney ever since, with limited success, but some. And, they understand. We start talking about these sovereign citizens and state nationalists and like that. Some of these people have good arguments behind them. They just don't do very well in our court system. And I especially caution people to not heed them on tax issues, because there's a long list of people who tried to pull that state sovereignty stuff in court and not pay taxes, and a lot of those people are behind bars. So
yeah, the sovereign citizens among them. All right, Go ahead.
Sorry, let me go back to it. Okay, so those are the chances of even the judges just seeing it. Let's look at what the case actually is. Oh, a lot of people are getting excited about the Brunson brothers' interaction with the clerk of the SCOTUS, and the article goes on, and I think accurately described that the Supreme Court is the most responsive court in the land to helping people that are people that are filing on their own behalf work their way.
And that means that the clerks, and I took it this way when I first heard about the clerks being helpful, is that the clerks are helpful. They're going to work with you. But a lot of people like to read into things.
Yeah, and they really talked about the exchange right here. There was a couple phone calls with the clerks. They say, "Oh, if there's nothing to the case, Doug, why is the clerk, actually helping them out? Why are they acting like they're anxious to get this thing filed? Yeah, they may just be anxious to get the thing done with,
off their desk."
Mm-hmm. But so there's a little context there. That's I think that's a good job of debunking one of the theories.
Mm-hmm.
So they write, some have interpreted this to mean the justices are eager to hear the case, proactively reaching out through the clerk. But no, that's what they always do. And they're talking about how justices try really hard not to give the appearance of prejudging a case. So,
you got to remember that they're supposed to be seen as apolitical, and that justice is blind. You've seen the statue, with the scales people write and the blindfold of it. And so they can't, they really go out of their way to make sure that they don't look like there's this preconceived thought or notion or direction or a favorite or anything like that. Now, that doesn't mean that they don't have political leanings, and a number of those justices, if not all of them, where they lean is pretty obvious, not just by how they rule, but some of the things they say. But that all said, they still go out of their way to make sure that they don't look like they are being subjective. They're trying to be as objective as possible. And part of it is because, you want to maintain the integrity of the courts, and the integrity being, once again, that justice is blind.
Yeah. And the next point in the article talks about that. And they basically say if they were to try to foreshadow what they're going to do, they would do it in a written opinion in another case, whether it be a majority, a concurrence, or dissenting. And they use the example of what Justice Clarence Thomas did with the Section 230. It was actually part of a denial for a petition of writ of certiorari. So, but he put in his opinion why, and it signals lawyers and other people building cases.
Mm-hmm.
I'm not going to take this case, but there's something here. If it comes to me presented a little differently, we can have that conversation. And
Gamble versus United States was another one back in 2019, because there was a lot of talk that there would be a lot of cases coming to the courts that might, certain precedent is, special. It can't be overturned. You just can't do that. And in Gamble versus United States, in his opinion, Clarence Thomas wrote, "Hey, if a ruling or an opinion is egregiously unconstitutional, it must be overturned." And I really think that was kind of a foreshadowing. He did that knowing there were going to be cases coming where they were going to turn over some highly embedded pieces of precedent.
Yeah, I was having that exact same conversation at the time. I agree 100%. And Thomas, I think, is probably better at the foreshadowing, or shall we say nudging, or less nudging than kind of, I'm going to shut this door, but I'm going to not lock it all the way. There is an angle here. You just got to find it.
Right.
It's like dropping little breadcrumbs is what he does. Yeah. There's a true art form to it. And the man, I mean, you know how I feel about Thomas. He's one of the great justices we've ever had.
Yeah, well, I will admit, not that I'm trying to beat my chest or anything, but when someone who disagrees with me screams at me, the only person I've come across that sounds like you is, well, maybe Clarence Thomas. And I'm like, was that supposed to be a put down? Because I didn't take it that way.
It's like, thank you very much.
Yeah.
Has there ever been a case where you disagreed with him?
Yes.
Okay, good. I would say the same. But
not many. But yes,
nice.
But one thing I can say about Thomas is he's the most constitutional. He and Alito are the most constitutional of the group. But on the same token, they also participate in the world that is today, not the world that we wish it was. And so sometimes I think they make rulings or provide judicial opinions. Get back to that word nudge, and nudge things back in the right direction, but they know that something must be done, and so they're willing to skirt it. A great example of Thomas, a disagreement I had with Thomas was McDonald v. Chicago, where Chicago was banning handguns, and Thomas ruled that it was unconstitutional because of the Second Amendment. He incorporated the Bill of Rights.
He did.
To
That's
the
the
case.
same. Yeah, it's the same thing we argued against with the New York gun law just earlier this year.
Yeah.
They had no business ruling. Period.
Yeah, but on the same token, what he had, he's existing in the world that is where there's incorporation. So what do you do? Let Chicago just ban handguns? Now my response is, well, yeah, let the people fix it. But from his point of view, that's not how he was looking at it.
Yeah, what I would hope we had some of that foreshadowing or breadcrumb dropping in some of those cases, and I didn't see it. Where he basically showed us where the path is to get this back, to get away from incorporation. He hasn't given us that signal yet of where the incorporation case would be. I don't know if there is one yet, but that's an angle we need to start talking about, because incorporation's got to be addressed. I mean, simply has to. Perhaps Dobbs did to some degree, but that's not really the challenging the 14th Amendment like it should be. We got to work on that angle, and it kind of made me laugh. Is the ultimate snake biting its own tail is, if you got a Supreme Court that was truly believing in original intent as the Constitution was written, and you took a case to them challenging judicial review, well, they've got to make a judicial review related ruling.
They got to use judicial review to decide on judicial review.
Exactly. So that's why a convention of states is needed, because that's the proper way to address bad law, is through an Article 5 convention. Congress.
Well, Article 5 convention and possibly nullification. Once again, and I'll say this as I've said a number of times, I don't believe that one or the other are the truly saving grace. One can be one or the other, but I think that they work well together.
Yeah,
along with other tools on our tool belt. Carpenter doesn't just have a hammer.
Yeah, one leads to the other. Nullification should be the first step, and that's just saying, no, we don't like what you do, and we're not going to follow that. And that's perfectly legal and needs to be done. That's why I follow the Kerry Lake case so closely.
But that needs to be done in a group, and that group say, hey, that's fine. You guys, you want to keep this up? We'll have a convention. There's enough of us.
Mm-hmm. That's why the one leads to the other.
Right.
Unfortunately, we don't have representatives who represent their constituents. We have representatives who represent national political parties that are owned by multinational corporations, but let's not go down that rabbit hole, because I do it every week. Okay, this talks a little bit more about what a great job Supreme Court does of people that are pro se litigants, meaning filing on your own behalf. And by the way, this video right here with Viva Frey and Barnes, that's a very...
I didn't watch it. I read the article. I didn't watch any of the videos.
I enjoy a lot of these guys' shows. I catch their content, maybe an hour or so a week, in the important cases. It's watching law videos when there's big trials can be pretty kicked. Where it's interesting is Viva Frey is Canadian. I don't even think he's licensed to practice American law, and he still gets our Constitution right more often than others. And Barnes is an establishment. His understanding of the Constitution is as the system is, not as we would like it to be. So that's why my disagreements with Barnes. But they're both highly intelligent and very objective-minded guys. I do enjoy them quite a bit. Next thing he goes, okay, Barnes dispels another myth about the Brunson petition. As noted on the SCOTUS docket and the Brunson website, the DOJ waived its right to respond to the petition at all. Basically, everyone goes, why would they do that? It's being spun as a good sign, saying the lawsuit is so solid that the DOJ simply can't even mount a defense against it. The article is going to make the argument that the highly politicized Merrick Garland is not going to simply throw up its hands and say, yep.
No. I mean, we're talking the firing of a bunch of Congress critters. If they think it was so solid, there's nothing they could do about it. They would still fight against it because of, even if it meant acting in a manner that was outside the rules, so to speak, because then they would be nervous. They're not nervous. That's the reason why they don't care.
Yeah, and then
they don't believe it holds merit.
Yeah, and I'll read the rest of the paragraphs. This is one of the takeaways anybody watching this should, keep in mind this week, so you don't get too excited. The highly politicized Merrick Garland DOJ is just going to throw up its hands and allow SCOTUS to unilaterally remove the entire Democratic power base from elected federal office without so much as making an argument, and to do so in a case that has been dismissed with ease at every level below SCOTUS? Does that really make sense to anyone? It's absurd, almost beyond the point of comprehension. It's nonsense. Now, on that argument, I'm gonna agree that that's a very, very bad argument. To say,
I'd not even heard that argument, but
yeah, that was one of the early ones. Yeah, when the DOJ, that was on the October 24th date. It was sorry, November, whatever, the day before Thanksgiving, whatever that date was, when the DOJ declined to even respond. That was interesting. So that's different than your Kamala case, because they did respond, and they responded when you're in the local courts. So they are taking yours more seriously. It's not ridiculous. It has not been just ignored.
Mm-hmm.
And of course, as you would say, as you said many times, they responded even when they weren't even a part of the case.
Yeah. And in fact, we called them out on it.
Uh-huh.
Well, what do you mean we don't have standing? You don't have standing. But anyway, I digress. Well, and you know, as a person that's been involved in cases, one of my frustrations is when you're told, well, it doesn't have merit, or the argument or the case is frivolous. There are such things as frivolous cases. There are such things as cases that don't have merit. But I have come across that argument so much that it's almost like a thumb your nose type argument sometimes. You're get away, kid, you bother me kind of, attitude. And maybe some cases deserve that, but that case is important to somebody. There's a reason it's there. And I think that while even if it doesn't have merit or may seem frivolous, that I do think that the justices or judges should at least give it, a couple of looks, whatever it may be. I'm not talking just about this case, any case. And to just dismiss something by reading the headline and deciding that it's frivolous without really understanding the merit, the true merit from the point of view of the person that's putting it forth, to me, that's lazy judicial practice.
The final part about Barnes and the validity of the case was basically, not only did the DOJ not respond, but the court didn't ask them for a response. The fact that neither the DOJ nor the court thought a response was necessary is the clearest sign that this case is going nowhere. That's pretty strong takeaway there. But let's look at the merits of the case. We've read the lawsuit filed by the Brunson brothers. In our honest opinion, it does not seem to have any basis in constitutional law. Hi, dogs.
Yeah, well, apparently Grandma's home.
Frankly
That's
speaking,
why the dogs are not in the office with me.
Frankly speaking, as found by the 10th Circuit Court of Appeals in their dismissal, it is frivolous, and they actually put that in writing. This argument is frivolous. Now, we can disagree on that, and I hope you do, because I read the case originally and said, okay, there's a couple of constitutional arguments to be made here.
I think it was well written.
But that there's their remedy is, their ask is nothing that is constitutional. And not only does a court not have the ability to remove a congressman or president from office, we don't want a court to have that kind of power.
Right.
And this article will go into that a little bit more. You certainly do not want that. I have said for 2 years that the only legal case for overturning the 2020 election had to come from the state legislatures. If state legislatures could recall their legislatures because they were convinced that the elections were not run according to their state law, they could make the case now, even then it's legally dubious, because you can't unplan whatever. You can't what's the expression? You can't undo the deed once someone's been sworn in, perhaps.
Right.
And they'll go into that as well. But this is why we were talking over the last couple of weeks about the Moore v. Harper case, which I think is far more important than this Dobson case, or the Brunson case.
It's definitely got more, for lack of a better way of putting it, merit.
Well, it does, and it's already been argued. They've already given oral arguments. The difference is Moore v. Harper can be ruled to reassert the fact that state legislatures actually are the final say on how their elections are run. And that's the way it's supposed to be.
Mm-hmm.
It could be taken retroactively to allow Pennsylvania and a couple of others to say, okay, that means the elections we ran that weren't done by state election law decided by the states in 2020, that's a possibility, although not a strong one. More importantly, if they get the right decision, it'll definitely give the state legislatures back their power to ensure that they get to be the ones who set state election law going forward. So it's a very important case. Whether it can work retroactively is dubious, but possible. And that's the far more important and likely case. But people aren't talking about that. They're talking about Brunson because, as you said, they want immediate gratification. Thoughts on that?
Well, what you were just addressing, there's a graphic on the page. If you go back up a little bit, and it shows the kind of was it up or down? No, it's down from where you're at. I'm sorry. Keep going. Okay. We're right there.
Yeah, I knew we were going to do this one.
Yeah, this graphic is fascinating. This is the way it is seen as, as the way things function. Remember, we have been convinced that we have three co-equal branches, and they're there to check each other, and this is proof with this graphic. The problem is some things are left out, and some things are there that shouldn't be there.
Well, let's go through it, because when I saw that graphic, I knew what you were going to say about it. So
you knew I'd pounce.
Because if you don't do it, I will.
Yeah. Well, there is all right. So on the upper left hand side, you see the red, white, and blue cap, and and that is the president. That represents the president for the purpose of this graphic. In the upper right hand side, you see the Capitol building. That would be the legislature, Congress. And then below, you see the scales of justice and the gavel, and that's the courts. And so the boxes going from the legislature to the left, impeach the president, and going down towards the judges, impeach the judges. So this is the check that the Congress, according to this graphic, has against the executive branch and the judicial branch. Then it goes over to the president, and it has these red arrows. Red arrow going back towards the legislature. He can veto legislation, so his check against bad legislation we are being shown, and nominate judges. He gets to put the people he likes. Of course, it leaves out the fact that also the Senate has to confirm them. Then you have the blue arrows coming from the judicial branch, one up towards the president, there to the left, declare presidential acts unconstitutional, and then the one pointing towards Congress, declare laws unconstitutional. The blue arrows are unconstitutional. Neither one of them are an authority to the federal courts. On top of that, when it says a veto legislation going from the president to the legislature, there should be another box above that or below that says override veto. So, and then when it goes from the Congress towards the judicial branch, there should be a box that says exceptions clause. Exceptions clause allows the legislature to make null and void any unconstitutional or other rulings or judicial opinions that they believe weren't right, that they want to get rid of. They can do that. Now understand, the exceptions clause doesn't mean that the legislature can do it all by itself. It does still require a presidential signing of that bill, or an overriding of that veto if there's a veto. Now that said, so if this graphic was accurate, the two blue arrows would be gone, though, and there would be two additional boxes pointing away from the congressional part of that graphic. And now, interestingly, does that still sound like we have three co-equal branches?
No, it absolutely does not. It makes it crystal clear that the founding fathers intended for the legislative branch, mentioned in Article 1, as opposed to Article 2 or 3, to be the most powerful. And we lost that in many ways,
Of
through.
course, it's also lost its basic character, its basic
Well, the idea, yeah.
makeup as well.
Well, the idea, and of course, the idea was that the Congress was closest to the people, and
Mhm.
that way, if something
Well,
was going,
closest to people and to the states.
yeah, well, that leads up to what I was going to say, because I always talk about, we talk about checks and balances, and everyone's so happy about their three co-equal branches of government, even though they're all usurping each other's power, because all three can legislate now. But more importantly, that the real checks and balances or between the federal government, the states, and the people. And the states were supposed to check the federal government. The people are supposed to check the states. Nobody gets to check the people. We are the ultimate power. That's where all power derives from us. And that's the real checks and balances. And that's what we got to get back to, is the states checking the federal government. It really comes down to a monetary question.
Exactly.
Yeah, it's the federal funds, and I've got some ideas on that. I'll be rolling out next year. I've got a did a bit of brainstorming the last couple of weeks, and I haven't shared it all with you yet. So that's coming. How to
Brainstorm.
How to demonetize the federal government, coming soon to a channel near you.
That doesn't sound like a brainstorm. That sounds like a brain hurricane.
Could be. Superstorm 2023. Which just cracks me up. They're calling this the worst storm in a million years or whatever, or 30 years because of my climate change and everything like that. So I'm old enough to remember in 2015 when we had something called the polar vortex, which was the storm of the century. And I remember it so well that because the other 49 states were all suffering with miserable weather, and California was having a nice little 80-degree Christmas and New Year's. It was literally 7 years ago today. I went scuba diving in La Jolla and made a video about it, and just to rub it into everyone I knew from the rest of the country about how we spent our polar vortex in this beautiful sunny day on the beaches of San Diego. So this is not the worst storm in 50 years. It's the worst storm maybe in 7 years. It's called weather, people. Get over it. Sorry.
Or as I like to say, I believe in climate change. It's called the four seasons.
Except for we don't get those here.
Well, we kind of do, but the four seasons are slightly different. You have mudslide season, fire season, construction season, and surfing season.
Oh, surfing season's year round, brother. Has to be. I was in the water 2 weeks ago. It's beautiful out. Real quick before we move on, what are the checks the Supreme Court has on the executive and the legislative?
They can offer a judicial opinion. In other words, they can bring to attention the problem. But in the end, it's still up to the legislature to determine whether or not it needs to be changed. And say, well, gosh, Doug, what if the legislature tells the courts to stick it? Well, we're supposed to be informed. We're supposed to be paying attention. And we're supposed to take action as a people or through our states, U.S. Senate, if that happens.
Which takes us back to Dobbs again, because, once the Supreme Court correctly put Roe versus Wade back to the states, right. Congress turned around and threatened to, we'll just put put Roe versus Wade into law. Well, that would be immediately challenged to go right back to SCOTUS, who, even though they don't have the power.
And here's the thing: by the proper constitutional rules and exceptions clause, actually, they could do that. Mm-hmm. But if it's unconstitutional law, then the states and the people need to be like, well, we're not following that. It's junk. Yeah. But by their rules that they've been following for the last 220 years, the courts can turn around and say, well, that law's no good. It's repealed. We strike it down. So how do they expect to overturn Dobbs' legislation if their rules of judicial review for 220 years has said, but the courts can strike down any unconstitutional law? So what happens is when you don't follow the proper procedures, manners and procedures that the Constitution has laid in place, then there's contradictions. And that's one of them.
Yeah, and the solution is to bad law is the states have to be the check on
Mhm.
the legislative
Well,
branch.
and again, if we never had the 17th Amendment, would these laws even be, making it beyond where they're going? I'll take that even further. If the state U.S. senators were appointed by state legislatures, then the state legislatures, the state Senate was appointed by the county leadership, or should I say legislature, one per county. Would we even be having these issues? Because that's the way it was in the beginning, folks.
And I think this article is actually going to get into where I was just about to reply to that, with whether the states had the ability to recall senators. But let's hold that until we get further down the article, because I think that's going to come up. For that reason alone, the case is dead on arrival at SCOTUS. Not necessarily. We already addressed that. There's nothing for the justices to rule on. They can't do anything about it. They can't remove Congress. They can't remove a president. They don't have the power. We don't want them to have the power. And that's what Tracy Beans is going to talk about for the next couple paragraphs down. And she makes a really good hypothetical scenario. If President Trump were to be reelected in 2024, what would there be to stop the left from filing a sternly worded brief with SCOTUS and having him removed from office soon after the 2025 inauguration? After witnessing how Article 3 and state courts have ruled on election cases, would you really trust them not to do so? Yeah, I actually would trust them not to do so. That's a bridge too far. If President Trump were to be reelected, they couldn't pull that, but she's making a hypothetical, and she's right about that part. You just don't want and we're seeing it. Excuse me. We're seeing this play out real time over the next 48 hours in Brazil, because their Supreme Court has been very tyrannical and has given itself all kinds of powers, and it is basically assuming an incredibly oppressive role, or a much bigger role in the government than it was ever supposed to be. There is a constitutional solution in Brazil, and the military's got about 2 days to act upon it. They can legally seize control of the government temporarily and challenge the elections. Whether they do that or not, we don't know. Bolsonaro gave what he called his final speech of 2022, and I heard part of it today, or a translation of it. I don't know what's going to happen in Brazil, but the people that are running around saying the military's in control down there, your information is not accurate compared to according to what I have on the ground and what's actually being done. Now, not that we would have real information, because the U.S. media is pretending there's nothing going on there at all. I mean, zero. It's like it never. Yeah.
Well, just like they pretend that nothing ever happened in Venezuela, and what did happen was all American corporations' fault anyway.
Well, that's actually not too far from the truth, to be honest with you. That's the part that gets me about the, shall we say, the radical left. They're right about a lot of things. Multinational corporations do control the government to a great degree. Their problem is a solution. Their solution is more government,
right?
And the solution should be less government.
Well, and also their solution is more collusion with other corporations instead of those corporations.
Yeah, sure. As long as we control the corporations, they'll be good. No, it's power corrupts. Absolute power corrupts. Absolutely. And the solution is decentralization, not centralization. That's where the inability to think logically kicks in. All right, getting into some more juicy stuff here. Once again, Tracy, you don't want SCOTUS to have the power to remove sitting elected officials. True. And this is a point I think Doug and I will both agree with. Congress always has the final say. Mm-hmm. One thing to be understood, under our constitutional system, Congress always has the final say in who is or is not president. Whether that means certification, removal by impeachment, or removal via the 25th, Congress always has the last word. And that's the way it was designed, and that's the way it should be. I know we're not crazy about Congress. They got a lower approval rating, than the Black Plague, but that's not because the design was flawed. It's because the execution was flawed. We allowed our politicians to be corrupted, and that has to be fixed, and that's done by taking money out of politics. But I'll digress. Really good argument here. The case often cited to refute this point is the landmark SCOTUS Bush versus Gore from 2000. While it is true the decision cleared the way for Governor George W. Bush to be declared the eventual winner, Congress still had to effectively sign off on the SCOTUS decision by its certification of the presidential electoral count. Now, this goes back to January 6th, which I want to get into, what actually happened and didn't happen. Had they chosen to do so, as Democrats attempted in 2000, Doug, were they election deniers? Isn't that? Congress still had the constitutional authority to set aside the electors from the state of Florida and vote to certify the 2000 election for Vice President Al Gore, instead of putting him in the White House, and SCOTUS couldn't have done a darn thing about it. Do you agree?
So, first of all, the courts had no business getting involved. So the very fact that SCOTUS resolved the disputed 2000 presidential election, that they don't have any authority. It should have gone back to the state legislature there in Florida to determine whether or not the Chads were fine, whether or not these were acceptable, so on and so forth. Someone says, well, Doug, but now you're leaving the chance up to the enemy, the state legislatures, because, of this and that. Well, no, if we went back to our original way it's designed, it would work fine. Our problem is that at the foundation, the construction of our system is inaccurate. Now, that said, Congress didn't have to effectively sign off on the SCOTUS decision by its certification, because Congress, once again, it can use legislation to overturn or to make null and void unconstitutional rulings and opinions. But then, once again, there's a third, more important piece of the puzzle here. Does Congress or the Supreme Court have any business at all getting involved in these elections at all?
Well, if they don't, who should have been the final arbiter of the hanging Chads in Florida?
The state legislatures.
Fine, I can live with that.
Yeah, but once again, when people start arguing about state legislatures, whether or not they can be trusted, well, they could be if they were comprised properly. I mean, do you think California would have two lefty houses of its state legislature if it was one per county in the state Senate?
No, we'll do Reynolds v. Sims another time. But no, well, I know where you're going. And of course I agree.
Yeah. See, part of our difficulty is people say, well, gosh, Doug, but if this happens, it's still a problem. Well, it's still a problem because the construction underneath is wrong. So here's a question on this graphic right here. Would Gore have been declared the winner if they had withdrawn Florida? Just basically say, we're not accepting Florida's electors. We just can't try. We don't know the answer. Or would they, but that's not a majority of the electoral votes. Electoral college 271 is not enough to win. It's what is it to win?
Well, if you can see right here on the screen, they're saying if Bush loses the Florida votes, does Gore automatically win? Is that spelled out clearly? Do you think? Because you need what's the number, 278 to win?
No. Hang on a second. What's
Are you picking up on my question and trying to find?
Yeah, I'm picking up on your question, but it's 270 to win, so he was fine. He would have won it. But let's say just for this discussion's sake that just one of those itty bitty little states had also gone to Bush, say Iowa, then no, neither one of them would have had enough. It's 270 to win. So if they had just disregarded Florida, 271 was enough.
Then how do they get Gore with 271? What was the actual result there? Hang on. That graphic is probably incorrect. I'm looking it up right now. You can entertain people. It'll take me a second.
Well, it's interesting because it's 270 to win. That graphic is inaccurate.
So Bush got 271. Gore
Well,
got
what that's saying is if they would have given Florida to Al Gore, it would have been 271. That's not.
They're actually flipping it. Okay.
Yeah.
Okay. Well, I was interpreting that they were saying, so that becomes up to now. That's only 513 votes. They're basically saying Florida didn't exist.
Oh, okay.
So this graphic is wrong, and I'm gonna.
There's a state somewhere there that Bush got.
Yeah, I'm gonna have to write Tracy Beans on this graphic because this is incorrect. She's actually responsive sometimes. I think I've gotten an email back from her like twice over the last 6 or 7 years I've been following her. I like her. She's good. In the aftermath of the 2020 election, despite losing, in quote marks, well done, 60 plus election contests, and that's in air quotes because you don't lose a case that nobody hears. Congress again had the constitutional authority to ignore court rulings and certify Trump as the winner. So that takes us to January 6th, the Fedsurrection. Tracy Beans is, and I don't know the other author as well, so I'm just going to give her all the credit for this writing. But he's a co-author. I just don't know his writing as well. So these authors call this the Fedsurrection, and they're going to make the suggestion that January 6th was a staged event to keep the electoral count from happening, or the challenges. They could not risk members of Congress changing their minds at the last minute to hear evidence because the courts wouldn't hear it. The American public was never presented with the actual evidence of the 2020 election fortification. The cabal, in air quotes, could not risk members of Congress changing their minds at the last minute due to political pressure from constituents outraged after hearing all the evidence and refusing to certify electors from at least 3 of the contested states. Had that happened, the election would have been declared contested, and the House of Representatives voted by state delegation, 50 votes total, to determine the winner. Republicans holding the majority of the state delegations presumably would have declared Trump the winner. Now, I like the word they use, presumably, because not all Republicans.
Never know for sure.
Yeah, well. And
also notice that she said voted by a state delegation. In other words, 1 vote for each state. So it's not based in. Someone says, "Well, gosh, Doug, the Democrats are in charge of the House." Well, that's not done that way. It's 1 vote per house, or per state.
And I wrote in that article I wrote in January of 2021. You read it, proofread it, and that was 100%. Almost all of it still stands true. I don't think I made my 10th Amendment argument well enough, looking back on it, but it was accurate. There was only one path to challenge that election, and it was taken away by what some would call a staged riot. And maybe we'll find out how many feds were involved in starting the violence that day. But what they did is they said, "Oh, a bunch of people acted out. We're going to punish the rest of America and not go through the normal process." And you don't get to do that. And that's what this lawsuit's all about, is you didn't go through your constitutional duties of certifying the election properly. Just because some other people acted out, whether it be a bunch of extremely radical MAGA Republicans or a bunch of Antifa guys working together with feds to stage it, which some people think, and I think there's an argument that can be made. What happened with the one hand shouldn't impact the other. And that's really the core of the Brunson case, is they didn't go through the actual process which they were supposed to do. And that was to make sure that the elections in all 50 states were run according to state law, and we can accept these as certifiable results and declare one person or the other the winner. They didn't go through that process. That's the flaw. That's the meat of the Brunson case, but he didn't make the argument properly. And I don't know that you can make it much better than they did, because we're limited by the interpretations of the Constitution. Oops, there we go. Your thoughts on that?
I agree. I don't know what else to say without saying something that might put me into trouble.
Yeah, we're trying not to get a strike. It's a touchy situation. I've been parsing my words relatively carefully.
Yeah, I've been careful not to say much at all. But here's the thing. let's get constitutional on this.
Okay.
Because the question has not been whether or not it should have been certified. For me, the question has been who could certify or decertify, because that's where the confusion was also for a lot of quote unquote patriots. Well, gosh, we're mad at Pence because he didn't decertify. Well, and he said, well, I don't have that constitutional duty. I'm there to count the votes. He was correct.
He
The
is.
word decertify doesn't exist in the Constitution anywhere. Therefore, the 10th Amendment comes into play. Well, Doug, maybe they just didn't expect a decertification. So we got to assume they could have said, no, that's not how it works.
Either they
knew exactly what they were doing. And we know that they considered decertify because certify is mentioned twice in the Constitution. And both times it says that it's the electors that certify. So now if they certified, then you would think then they could be decertified. And if that was the case, they would say who could decertify. By not using that word, they did.
10th Amendment.
The 10th Amendment. If it's not given to the federal government, it's not prohibited to the states, it's up to the states, meaning the state governmental apparatus.
And that's exactly why I said when I was referring to the article I wrote 2 years ago, I should have made a stronger 10th Amendment case. I didn't rely on that enough. Yeah. If I were to rewrite the article tomorrow, I would have used that argument you just made.
Yeah. Well, I tell people all the time, that everything is in the Constitution. And if it's not, it is.
Well, yeah, that's like my circle of power example. All government power, however you define it, it's a pie. Mm-hmm. And what the founders did is they sliced out a couple slices of pie, said this is for the federal government. And all the rest of the pie, different slices, whether it be, I don't know, regulating, and I know you hate that word, regulating commerce or trade among states, what have you, are reserved to the states by the 10th Amendment. Anytime the federal government takes off another slice of pie and they don't go through the actual process of amending the Constitution, they are doing so illegally and unconstitutionally. Right. And that's really what we're battling here, is to get our pie back. I want my pie. and that's really what it is. And it's the pie never gets bigger, never gets smaller. There's only so many powers a government can have. That's it. That's just the nature of government. And
well, and also it's the nature of human nature.
Yeah, I mean it's just a reality. It's going back to our right-left scale. Mm-hmm. You have 100% government, which is tyranny. You have 0% government, which is anarchy. You want to be as close to 0% government as you can be and still maintain order. And that was the entire goal of the founding fathers in creating the Constitution. We know this because the whole reason they convened in Philadelphia is because they created the Articles of Confederation was based on a lot of these same principles, but they found out really quickly it wasn't quite enough government. Right. So they had to assemble and said, look, we need a little bit stronger central authority. They didn't trust it. They didn't want, they go, oh, these are 13 independent sovereign nations saying, okay, we're going to bind together for a common defense. It'd be kind of cool if we can trade together. But, we have similar values and backgrounds, but we don't trust each other. And now we're going to create a new entity that's got power over all of us. Well, let's put some shackles on this beast we're creating. And that's one of your favorite, one of your better analogies. So I'm not going to steal your material.
No, go ahead.
Put the beast back in his cage.
Yeah.
Really good point here. The person most harmed politically by the events of January 6th was President Trump himself, and that's the clearest indication that he had nothing to do with it.
Well, aside from the fact also that a breach happened 15 minutes after he was done talking, and it took 45 minutes for people to get there.
The breach happened 15 minutes before he was done talking. And it was before he was. The breach already happened before, while he was still speaking.
I was going by the testimony in Congress, but yeah, you're right. Now that I go back to the time frame, I actually wrote an article about it, broke it down. People that I knew were there, how long it took to walk. You're in a crowd of 1 million people or hundreds of thousands of people or thousands, whatever it is. You're not going to be walking at normal speed. Number one. Number two, most people are going to stop to go to the restroom, grab a bite to eat, or stop by their hotel room. So even if but even if they didn't do any of those things and they went straight and there was no crowd, it still would have taken 20 to 30 minutes to get there.
So the January 6th committee, which is disbanded now, has been releasing a lot of their testimony. And what came out, it was either yesterday or today, I read it today, was the Ray Epps testimony.
Yeah, I was reading that today too, but go ahead.
Oh my goodness. You watch the video of everything I was in Ray Epps. We got a pretty good idea of what he was saying on January 5th and 6th. And it's quite clear. It's all about going into the Capitol. And then Adam Kinzinger leads him through this questioning. And the entire time Ray Epps goes, no, I was trying to protect people and tell them to be peaceful. And it's just garbage, hot garbage. I have a little bit of a concern that the special counsel, Jack Smith, that was named by Merrick Garland, is specifically so that the incoming House Judiciary, which should be led by Jim Jordan, can't access the January 6th files because they're going to hide them away, saying, ongoing criminal investigation by the special counsel, just like they did in 2016 through 2018 with Mueller. That's a way of keeping sunlight from happening. So I am concerned with that a lot of the testimony that was given behind closed doors will not come to light. So that's going to be a little bit of a legal battle. I've got a bit of faith in Jim Jordan. A bit. We'll
see, I get upset with these. Well, that guy's a rhino and that guy's not. Well, when it comes to the Republicans, there are those that are beyond repair.
Mitch McConnell.
There are those, though, that while they may have done a handful of rhino type things, it doesn't necessarily make them a rhino. It means that they made some very bad decisions or they were tempted by money or whatever the reason. But there are other times when they are absolutely fantastic. Trey Gowdy was one of those people. Jim Jordan is one of those people. Now, I have to admit, he's better than not better more often than
he's got some
Trey
great sound
Gowdy
bites.
Was.
Yeah.
But, nobody's going to be, none of them are perfect. So, let's just because one of them disappointed you once or twice, that doesn't make him a rhino. It means they disappointed you once or twice. And,
they've got a lot of people in their ear and they've got a lot of interests they're trying to represent, including their own. But it brings up a really interesting conversation. If I can just take us down a quick little rabbit hole, is one of the big conversations next week is going to be Kevin McCarthy becoming the Speaker of the House. There are 5 holdout Freedom Caucus congressmen in the Republican Party. They're saying never, Kevin. Marjorie Taylor Greene wrote a Twitter thread last week, or in the last week, defending why she is supporting Kevin McCarthy, and she says that he's made a bit of a shift towards the what would be considered the America First base, and she makes some pretty good arguments. And she's not she doesn't have a ton of political savvy, but she's got pretty good instincts for the movement. She's definitely comes from the America First base. Right. It's worth discussing. At the end of the day, does anybody else have a chance to take the gavel? Yeah, it's possible. I mean, someone has to get it. But right. That omnibus bill already took a lot of the power away from this congressional majority, and basically they exist for the next 2 years to run investigations. And I'd like to see these investigations start quickly. I want to have the right people. And I think what it comes down to, if you look at what Kevin McCarthy has promised to do and knew nothing about his background, you'd say, absolutely, I love this guy. His promises as Speaker of the House are just spot on. And it includes the ability to remove the Speaker quickly. I forget what the term is. But we know his past. And, us in California know, where his power base is.
Track record's a big deal.
It is, but people can change their mind. People can grow.
This is true.
So I'm certainly not being pro McCarthy. I mean, that's never going to happen because I watched what he did to the grassroots movement during the primaries this year in California with a lack of money going to people like the running for Congress, like a couple friends of ours. But perhaps he can be pressured. We'll see. All right, back on track. Let's see. How are you doing on time? We're at 6:51.
Oh, we're like an hour and 20 minutes so far. We're like 20 minutes over, but I'm not upset.
Well, it's probably going to take us another 20 to finish this up. and maybe
Okay.
longer because there's some good questions coming up. So, how much time do you have? Do you have a deadline? I'll try to.
No, I don't have a deadline.
All right. So we're going into your wheelhouse. The Constitutional Convention of 1787 and the Electors Clause. This, however, further undermines the merits of the Brunson Petition. The notion the founders never anticipated malfeasance or foreign interference to occur in a presidential election is simply not true. In fact, they expected it. Article 1, Section 4, the Elections or Electors Clause of the U.S. Constitution was the most hotly contested debate during the Constitutional Convention. I disagree with that statement. I think judicial review was even more contested.
I think slavery was more a hotter issue. But anyway, continue.
The Emoluments Clause was added out of fear that European monarchies would simply bribe U.S. government officials with titles of nobility and seize control of the newly founded country that way.
Mm-hmm.
This requirement that that a president be a U.S. natural-born citizen was included. A couple of Doug's favorite topics here, so I'm just going to zip it and let you go.
All right. Well, when it comes to natural-born citizen, the Kamala case is actually a large part of that. But let's get back to one of my favorite statements. One of the things I like to tell people is the United States was a third world country. They were still developing in a world of empires. And these empires that were in the world wanted nothing more than to A, divide America, and B, take a slice of it for themselves. So, and the founding fathers were well aware of this. Also, the other concern, in addition to foreign entities wanting to slice and dice and take parts of America, were the Tories. These were Americans who had felt that the push for independence was a bad idea. They believed that we as a country or as a Commonwealth or whatever they thought America should become should be under the umbrella of the British Empire. That was the way to keep it safe. Because if you're in a world of empires, you want to be a part of one of the empires. If you're in a world of empires and you're trying to make it by yourself out there, it's sort of like a tortoise crossing a highway, a very busy one. You could go splat. So there were concerns about foreign influences. But there was also another concern. They also understood that there was for lack of a better way of putting it, a global hegemony that existed. And so the Americans did something very interesting with their Constitution. Now, I can hear the words coming already on the tips of people's mouths. Isolationism, protectionism. Perhaps, but the Americans specifically made sure that the U.S. government and the United States was as separated from Europe as possible and as unlike Europe as possible. The idea was, we don't want to be a part of that game. We want to create our own game. And so when it came to natural born citizen, our elections, coining money, all of that stuff, they specifically set out to protect us from foreign influence or foreign infiltration. Now, which brings us back to the elections. You'll notice in Article 1, Section 4, this article refers to that section and how it was highly contested. You'll notice something very fascinating about it, and very few people notice this. What we're told is, according to Article 1, Section 4, the state legislature must prescribe the manners and procedures of all federal elections. That is not what Article 1, Section 4 says. Article 1, Section 4 says the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. In other words, the federal legislative offices. Then it says, and here's why this is important. And then it says, but Congress may at any time, by law, make or alter such regulations, except as to the places of choosing senators. So what it's saying is the state legislature is in charge of the manners and procedures of the senatorial and House of Representatives elections. And if they do something that Congress thinks is a little wacky, Congress then can make a law to fix that. Now, here's my point, because we've been talking about presidential election here because of the Brunson case. It doesn't say anything about the president, does it?
It does
Senators or representatives. So where does it talk about presidential elections? Well, gosh, if you go to Article 2, what it says is each state, this is Article 2, Section 1, second paragraph, each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the number of senators and representatives to which a state may be entitled in the Congress. Notice there's nothing there that says, oh, but Congress can make a law if they have to fix it. It's not there. And then it doesn't say here that the state legislatures choose all this electors. What it says is the state chooses the electors based on what the state legislature has decided. How to do the rules, how to do that election for the electors. The way they did it, pretty much, I think all of them did it this way, if I remember properly, is the number of electors is based on what? The members of the House and the members of the Senate combined. So if you're in, say, Nebraska, which right now I think has 8 electoral votes, 6 of those are based on their number of the House representatives, and 2 of them because of the Senate. 6 plus 2 equals 8, right? So those 6 would be elected, if they were doing it the old way, by the people through districts, typically the congressional districts. So each elector would represent a congressional district. The final 2, which are there because of the Senate, would be chosen by the 2 houses of the state legislature. So the state house or assembly or whatever you want to call it, and the state Senate would choose the last 2. So the electors were a mixture of people that were directly voted in by the people and indirectly voted in by the people. Then the elector would vote for president, representing the district that had voted them in, or the House, which had voted them in. And they're going to vote in a manner which runs consistent with the district or the House in which they represent. Now, if that's the case, and districts are set up by population from the House, are all of the districts going to be big cities? No. The big city might dominate a district or 2. The rest of them are likely going to be in rural areas. If we go back to the Reynolds v. Sims thing I brought up earlier, your state Senate is going to be dominated by a rural voice, and the state House or the Assembly is going to be dominated by the city's voice. So what that does is the electors who's voting for president are going to largely represent the rural voice with a little bit of the population centers in there. Why do I bring this all up? At this whole process that I just talked about, there is no place in this Constitution that gives the possibility of having anything to do with that process to any other body other than the state legislature.
It's almost like they had a good plan.
So now going back to Article 1, Section 4, the reason why I bring that up is because people are like, well, yeah, but Congress can for the Senate or House elections, not for the presidential election. So therefore, based on what I just said, any congressional influence, any gubernatorial influence, any DOJ influence, any court influence on the presidential election is outright unconstitutional. It's totally up to the state legislature, period.
Well, that takes us back to the case, and a couple of those articles are going to be discussed. There's arguments going to be discussed. I'm going to fast forward a bit. Obviously, they talked about the fear of foreign influence quite a bit. We'll skip over that since Doug covered it quite nicely. With divides already forming between North and South, free states and slave states, they knew a unanimous candidate to fill the position was next to impossible. Of course it was. It was never going to happen. Founders realized these elections would be fiercely contested. And this is really interesting. Both Adams and Jefferson, in their capacities as vice presidents, think Mike Pence on January 6th, presided over highly controversial congressional certifications that resulted in themselves being named president. So Pence, had a little bit less of a conflict of interest than those guys did. The legality of their actions is still being debated to this day by constitutional scholars. Yet despite this, there was never any possibility the Supreme Courts of the time had the power to retroactively review their actions and remove them from the presidency once
Now
sworn
the
in.
court's business.
Yep, thank you. But that's summed it up. We'll skip past it.
Yeah. So and when I say these things, I love it when history like confirms it.
Oh, it's almost as if you've read history a few times.
Yeah, a few times.
Actually, it's almost as if you studied this stuff.
Almost.
The article is going to go on to explain why you don't want the Supreme Court to have that ability. If anybody looks up this article, this little 13-minute piece between Sebastian Gorka, who I'm not a huge fan of, but he does say some good things, and Jenna Ellis, who I'm not a huge fan of, but she does say some good things. They talk about this pretty well. And the main point of this 14 minutes of the video in this article really talks about what we alluded to earlier. There's a difference between the way the Constitution should be interpreted and the way it is being interpreted.
Right.
And these people both are making arguments for how it is being interpreted. And they make good arguments, and they're not wrong. They're just, I'd like to see them make a firmer stand towards original intent. One of the popular theories that SCOTUS took the case. No, they did not. To hold over the heads of members of Congress in the lame duck session. No, that's ridiculous. And you don't want a Supreme Court that would do that. That goes back to they don't have the power. They allude to the 2018 North Carolina congressional district election, and that's a recent case. So what happened was a Republican in North Carolina got caught illegally ballot harvesting, and basically did not get sworn in and that's the point they're making here. Is a lot of people who want to say that the judiciary has the ability to overthrow an election use this case as an example, and I've probably alluded to it incorrectly a couple of times over the last few years. The point they make here in the article, and I looked it up and they're correct. It wasn't the judiciary who told him he could not be seated. He's declared the winner. It was late, but he had his victory later overturned. Never had his election certified and was never seated in Congress. Had he been seated, or certified or seated, any effort to overturn the election result and remove him would have fallen to the U.S. House of Representatives. The courts did not have final say in the income. This is correct. All right, so here comes the fun one, Doug. Fraud vitiates everything. That's one of the ones that gets thrown around. They cite Throckmorton versus United States. And when Doug and I were first getting to know each other, I brought this one to his attention, and we've had a lot of fun with this ever since. The Throckmorton case. And basically it says that any contract that's if
there's any fraud, it's done. The whole thing is just
it goes back to square one.
Yeah.
While this type of legalese may sound pretty
vitiates or vitiates.
I say vitiates, but
because I've always said vitiates. But anyway.
Well, you're probably correct, because there's a whole litany of words that I've read a bunch of my life but never heard pronounced, and therefore I go with what makes sense to me. And I've been proved wrong on so many of those more often than not. I'm wrong on it when it comes to those type of situations. So we'll go with vitiates for now. Suppose someone is telling you the legal opinions in U.S. versus Throckmorton supersede a plain reading of processes spelled out in the first 3 articles of the U.S. Constitution. They're kidding themselves, or they've got something to sell you. What their argument here is that, look, the Constitution supersedes the Supreme Court law, which is correct. The Constitution, if it's interpreted properly, clearly is superior to a Supreme Court decision.
Right.
But yeah. Texas versus Pennsylvania. That was the case that was brought by the state of Texas. 20 other states joined in. President Trump.
The one that SCOTUS would not take.
Yeah, and that was the problem. That was the case.
Let's go with kind of, I think, what she's saying here, and I have said this all along. Article 3 says that any time a state is party to a case, then the Supreme Court has original jurisdiction. Now, everybody, including the state, deserves its day in court and should have its day in court, must have its day in court. So if the Supreme Court is the court with original jurisdiction, then that means the case can go nowhere else. They are literally the only court that can hear the case. If that's the case, then they can't say no because the state has a right to have its day in court. So the very fact that the Supreme Court said, nah, we don't want to hear the case, to me, was totally against the point of the Supreme Court having original jurisdiction.
Yeah, it's actually, I was going to say, why have a Supreme Court in the first place if they don't take up one of the most important cases, which is clearly under their purview? Right. And that takes us back earlier into the article. The reason, people suspect that, the January 6th events might have been staged, what have you. And I'm comfortable saying that. Might is me mitigating that statement. I'm pretty confident based on what we now know that it was. They could not allow the American public to hear those arguments. And that does not bode well for our confidence in the Supreme Court not taking that case. It only takes 4 Supreme Court justices to take a case, which means 6 out of 9 said, no, we don't want to have anything to do with it. And I think they all shirked their duty. Mm-hmm. That's a tough one.
I agree.
That Texas versus Pennsylvania case should have been heard. Now, interestingly enough, they are now here. They actually did hear the case in Moore v. Harper because the exact same arguments over whether Pennsylvania's legislature has the right to set their own election law is at stake now, 2 years later. So,
well, then the question too is, do they have a right to set their own election law? And number 2, who has the authority to do that? Can the Secretary of State, can the governor just make decisions without the state legislature, or does the state legislature need to be either party or the sole party?
Well, it should, and it's clearly laid out that it's a state legislature. I mean, there really is not a whole lot of constitutional question marks when it comes to that.
Yeah, well, remember who we're dealing with.
Well, there you have it. But they should have taken the Texas case, and they actually did take it with Moore v. Harper. So, if you look at the 2 arguments, lay them down side by side, there's enough similarities to say, okay, so does that support, SCOTUS rejecting the Texas v. Pennsylvania based on standing, but the North Carolina legislature does? I don't think so, but
right.
History may make.
There's an inconsistency there.
Yeah, there is. That case should have been heard. The American people deserve to hear it because the vast majority of the American people never saw the proof of the alleged improprieties of the 2020 election, and they still think, oh, that's a conspiracy theory. No, we saw what we saw. We know for a fact that they changed election law in many of the swing states, and it wasn't done by the legislatures. It's supposed to be done. By definition, they should be null and void. That's the argument. They're going to go on with more Texas v. Pennsylvania. Ken Paxton denying that. So 6-3 said lack of standing. This is interesting. Lack of standing is a legal doctrine that didn't even exist in the first 150 years of American case law. Love that word, case law. And was never contemplated by the founders of the Constitution, Constitutional Convention, Federalist Papers, or anywhere else. In our opinion of the writers, it represents one of the worst acts or inactions in the history of the Supreme Court. And I would agree.
So, gosh, when would that make case law emerge?
let's see, about 70 years ago.
Yeah, not very far after the Progressive Era, and during a time in which less than liberty-minded ideas were being thrust into our system.
For love of God, just blame it on Hugo Black, because that's who did it. I mean,
one of the 3 worst Supreme Court justices of all time.
Yeah, 100%. Well, according to our good friend, I guess we don't know him.
Yeah, I think we ought to. Well, I think we could probably throw Warren and John Marshall Harlan in there too, but that's just me.
Yeah, there's a few of them.
John Marshall Harlan was Chief Justice in like the early, like the first decade of the 1900s, something like that. He's got some doozies too.
So the article is getting close to its conclusion. It says there is no magic bullet. As we stated in the beginning, our purpose for writing this column isn't to dampen your spirits, rob you of hope, or quote unquote black pill you. And it's certainly not to enrich ourselves, or to add to the following. As Tracy Beans commented in her Telegram voice memo thread, I know there's a lot of people going bonkers crazy over this thing, and they get very mad at you when you point out the deficiencies. And we'll get some negative feedback, Doug, for doing this.
Mm-hmm.
But the deficiencies exist. Don't kill the messenger just because I'm pointing this stuff out. I'm blown away by how angry people get. Well, of course people are angry. They think some really bad shenanigans happened, and they don't like the direction of their country, and they don't feel like they're getting their voice heard. People are ticked off, and I don't blame you. I am. There's a reason I do this stuff. The story is clickbait gold and has caught fire on social media and among the America First base like few other stories we've seen. And that's true. There's always a plan or a miracle case for which we all keep waiting. This isn't it. This is not the magic bullet. That's the argument.
And it's funny too, because saying that no magic bullet is just a reiteration of something I say all the time. There is no magic bullet, and it's not. We're not going to get instant gratification. It's a process, and we have to go through that process.
Well, that's exactly what this article is going to conclude. They're saying, look, this doesn't. Here we go. They didn't do it overnight. It's going to take time, a long time, with setbacks along the way. And once we're back, and make no mistake, we will get back. We will have to struggle relentlessly to ensure it never happens again. And that's what Benjamin Franklin was saying to Mrs. Powell. It is a republic if you can keep it. And this goes back to fight locally, act locally, take care of your business in your own backyard. Learn this stuff. Give yourself the, what you need, the information you need to have these conversations and get people involved, because it matters. And that's where this stuff was lost. We say it every single week, act locally. But that's what you got to do. I will be having a good time this weekend, going to the New Year's Eve party for the first time in a few years. I even got some local Temecula-grown almond champagne to bring. And Monday morning, I am going to get some work done and jump right back into the fight.
It's funny because New Year's Eve, my wife and I were going to go down to the San Diego waterfront and to welcome it in. We had actually gotten in a hotel room for a couple nights because, we've lived in Southern California our whole lives. And then when we go on vacation, we go everywhere else. I have lived in Murrieta since 1989, and not once have I gone to the Balloon and Wine Festival. I lived in San Diego for 5 years. Not once have I stayed the night at the waterfront or enjoyed what it has to offer. And so we thought, hey, let's do that. And then her work decided that she was going to be busy that night. So we canceled all of it. So I will be here in my home on New Year's Eve. We have done New Year's Eve parties, and they are a good time, but not this year.
The big effort for me in January is going to be helping Audra Morgan lead get the San Diego North County canvass done. And I've maintained for quite some time that you're not going to get elections you can trust with until you clean up the voter rolls, and that includes in all 50 states. Anybody wants to get involved in something like that, let me know. There are efforts to canvass the voter rolls in every state in America right now. That's a big part of the problem. It's making sure only eligible voters are on those rolls. I bring up the argument that Judicial Watch in 2018 won a case and forced Los Angeles County to purge their voter rolls of 1.8 million voters. That means they proved in court that there was 1.8 million people listed to be able to vote that were not eligible. If you think about that and take it around the country, there's your margin of victory by a long shot. It's all about the voter rolls.
Mm-hmm.
And this is something we can all do. And canvassing is not that difficult. But you just got to get a group of people, get access to the voter roll database, which I can help you with, and that's where the work is done. Get involved locally. That's what we can do. We can't fix the Ronald McDaniel versus a Harmy Dillon fight. That's at a different level. That's
at the foundation of activism is information, education, being informed. A lot of people don't even realize there's a problem, and when they do realize there's a problem, they don't know what it is or the details. And so I've always been on the education end of things. And when it comes to 2023, I've got 4 big pushes. One, a Constitution distribution project where I want to get pocket constitutions in the hands of everybody I can. Number 2, I want to start workshops to teach people how to talk to their critters that they voted in or that they or represent them. How do you set up the appointments? What kind of things should you say? Is it okay to just talk to their staff? When you do talk to them, what kind of questions do you ask? What kind of responses should you have? Things like that. And so I'm working on setting up workshops for that. The other 2 projects are books. I've got to finish my U.S. history textbook and my 1607 project book.
Well, I'm very much looking forward to that one. I've actually deliberately avoided the topic that other people have debated, 1619 versus 1776 and stuff. I'm looking forward to reading yours.
Yeah, it's essentially done except for a few chapters, but I realized I screwed up my bibliography. That's going to take a lot of work to fix. But
if I actually get my planned book into action, and once you start it, it gets moving.
Yeah.
But what I'm going to write about is basically taking a look at the geopolitical and economic factors that led to these multinational corporations dominating our governments all over the world. And I've got almost every chapter written in my head, and I've done the homework. It's just a matter of putting it down on paper. It's a book that will make me a little unpopular, so I'll probably write it under a pseudonym, but it would probably kill my professional career. And but we both left out the big project that is probably going to launch in January. The Constitution Restoration Society should be up and running, the new website, and we're going to be consolidating a lot of our efforts there. Probably moving some of our shows onto that platform. We'll have things like message boards and some other interactive opportunities to just be an education center and see if we can get this message out to the rest of the country. And that's
that said, there is one project that I have finally. I had completed it, but finally got it live. I have a book called Repeal Democracy, which has been done for about 2 or 3 months. And I've been having challenges with the publisher who bought the company I use, and challenges because of content and the cover. And I decided rather than continue to fight with them, I'm going to try something. So I shut it all down, reversed everything I did, and I started all over again. And it went through within a day. So here's my now thoughts. The group of people who reviewed it the first time were a bunch of whatever you want to call them. But I didn't get that same group to review it when I submitted it a separate second time. I got someone who either didn't care or agreed with me. And it went through in a day. Normally, by the way, it takes 72 hours. That's what was really funny, is it was literally the opposite extreme of me not being able to get it published, probably because of reasons that, social media likes to censor things and all of that, to like 12 hours, it was ready to roll, and it's supposed to take 72 when I resubmitted it under a whole different attack. So it went live last night on Amazon, and I should be getting copies for distribution. I do have for Repeal Democracy. It's online if you want to buy it at Amazon for $20. I don't have any copies with me yet, so it's not in my store yet. And for those of you who attended the annual dinner in September, I decided to make those special edition copies that are only going to those people who were at that dinner hardcover copies and a slightly larger setup. So that way it for sure are unique, makes them very unique. So there you
go. What I was going to finish it up with was we're talking about the Constitution Restoration Society and all that good fun stuff.
Oh yeah, there is that.
Yeah, we got some good stuff coming. Look forward to feedback because Doug and I came on our good friend Andrew's channel several months back, and this was kind of us practicing. We work together in person. Doug's always the constitutional instructor. I fill in from occasionally, and I put in my I chirp in a little bit, and
you are very knowledgeable on a lot of topics. And what's really nice about it, there's a real compliment right there, because what I really know, he has learned quite well, but the things I don't really know, he does. So it is a good compliment, definitely a good compliment.
Yeah, so we're basically building towards doing a show with Doug and I, and Andrew's nice enough to let us practice as he tries to build his channel and stuff like that. So we've enjoyed Andrew's hospitality. I'll keep doing this show, when I have free time on Fridays, because I like Andrew a lot, and he's growing as a pretty good host when he doesn't have the flu, which he does right now. For those of you who don't want to know where he is. But we've got some good stuff coming. 2023 is,
I think 2023 is going to be a big year for not only the movement, but for you and I in particular.
Yeah, there's a lot of battles ahead, and we need everybody behind us and all the people who support us. But
I was a Navy guy. All hands on deck. All hands on deck. That's my way of putting it.
Spread the word. We got some really good stuff planned. I'm looking forward to it. Shall we sign off?
We can sign off. And it's funny because I was wondering about that chat room. Like, man, is anybody even there? And then they responded after you asked. And I do. I agree with you. I think it's some of the better content we've put out there. But it is good to see those of you who are chiming in. And Chris, I love the final comment there. I'll always be hooked up with you guys. Have learned tons. That's the point.
Well, now more important is, are you spreading what you've learned to other people? Because that's why we do this. It's you get to educate yourself, and you get to a point when you're dangerous, and you create a bunch of mini Chris's, and that's what we want.
Yeah,
we love it. We love the fact that you're one of the most consistent people here, but I want 10 more of you. And I want all of them. That's what we're trying to do. We're going to grow exponentially. And look, the truth will set you free.
Yeah.
That's what we're going for.
Of course, now that said, and this is a blanket statement, not necessarily to anybody in particular. What we do takes funding. So just be aware that as we move forward and as we get certain mechanisms in place and ability to for you to contribute, please participate. I myself, just with what I do, 2 radio shows and so on and so forth, takes funds. As a matter of fact, my radio show in KMET is still about $1,600 short, and it's due in like 2 weeks. There's always this. So just, not that I'm trying to make a plea. I'm not asking you for money per se right now, although I wouldn't complain if you decided to help out. But the movement isn't just learning and participating. For some of us, the participation, because we don't know what to do, is to send funds. So, there's always funding needs. So just be aware. And we always appreciate it. And in my case, that would be politicalpistachio.com or douglasvgibbs.com at the moment. Find the donate button. That all said, am I ready to sign out?
You are ready to sign out.
United we stand, combined we kick butt. God bless America, my friends. God bless you. We'll see you next week.
Cheers, everyone. Happy New Year. Look forward to seeing you soon. Good night. How do I end it?
Just leave.
I found I actually have to hit the end broadcast.
Okay.